Yes. Good evening, everyone. Good to be here again. Good to be here again. Welcome to Legal Lounge. Welcome to Legal Lounge. And we're happy to be. This is episode 3 of Legal Lounge. This is episode 3 of Legal Lounge. Now, Legal Lounge is powered by EL Everything Legal. And as we have always said, this is a free platform open to all students of the Nigerian Law School and, of course, all members of the public, but is channeled to students of the Nigerian Law School to assist in excelling in the bar exam. We started about 2 weeks ago. We've had episode 1, we've had episode 2, and this is episode 3. I think episode 1 was on the introduction to property law practice, one of the key courses in the Nigerian Law School. And episode 2 was on the topic mortgage in property law practice. Now, for episode 3, we would go to another course in the Nigerian Law School, and that course is civil litigation. Now, in civil litigation, the topic we would dwell on today is matrimonial causes. Is matrimonial causes. Matrimonial causes. That is issues that have to do with marriage, divorce, dissolution of marriage, and all that. But then you must know, for members of the public that are tuned in, this is focused to assist the students of the Nigerian Law School. It doesn't stop other members of the public from learning, but the focus is for the students of the Nigerian Law School. Now, let's get to it. Matrimonial causes. In civil litigation, one of the things you are to identify in a scenario is known as cause of action. Cause of action is one of the first issue you are to identify in a scenario of civil litigation. And there are a lot of causes of action. The causes of actions are numerous. Now, one of the causes of action is known as matrimonial causes. One of the causes of action is known as matrimonial causes. And it is straightforward to identify matrimonial causes in the scenario. Listen carefully, class. Matrimonial causes have to do with issues that arise from marriage. I repeat, matrimonial causes have to do with issues that arise from marriage. So when marriage has taken place, where there are issues arising from marriage based on the validity of the marriage, divorce, that's dissolution of the marriage, and any other issue fall under the cause of action known as matrimonial causes. Fall under the cause of action known as matrimonial causes. Now, to begin this class, we would start by defining marriage. We will start by defining marriage. Before we define marriage, you must know this, especially students preparing for the bar exam. In the topic matrimonial causes, you are concerned with one type of marriage, and that marriage is statutory marriage or marriage under the Act. The Act we're referring to here is the Marriage Act. So we're concerned with statutory marriage known as marriage under the Act. This does not mean that there are not other types of marriage. There is customary marriage, marriage under custom. There is also Islamic marriage, and there are procedures for dissolution or settlement of issues arising from a customary marriage, whether judicial or extrajudicial means, right? And there are also procedures for settlement of issues arising from Islamic marriage, whether judicial or extrajudicial means. Now, for Islamic marriage, don't forget there are basic extrajudicial means like talaq, Talaq, and then khul, Khul, and mubarak. Now, for talaq, it's one of the ways of dissolving an Islamic marriage, and it is done by the husband, where the husband divorces the wife using talaq, right? It's often said 3 times, and it ends the marriage unilaterally by the husband. Also, khul is done by the wife. And you must know this, we are not concerned with all that. For the bar exam, the type of marriage we are concerned with is statutory marriage, also known as marriage under the Act. Statutory marriage, also known as marriage under the Act. Now, in the case of hide and hide, I repeat, in the case of hide and hide, a marriage is a voluntary union. I would repeat, a marriage is a voluntary union for life between one man and one woman. I repeat, marriage is a voluntary union for life between one man and one woman. Now, under the Act, it is clear and evident that the type of marriage supported is monogamous marriage. The Marriage Act does not support polygamy. What is supported here is monogamous marriage under the Act, as you are concerned with for the bar exam. Now, a fun fact is this. In Nigeria, there is nothing like signing divorce papers to dissolve a marriage. Listen, in Nigeria, the procedure of signing papers to dissolve a marriage does not work here. The appropriate procedure for dissolution of marriage is by instituting an action in court, filing an action in court, which is commenced by petition. And the court must give a decree, an order dissolving that marriage before the marriage stands dissolved. So we do not sign divorce papers in Nigeria. Divorce or dissolution of marriage is a procedure, a judicial procedure. Please take note of that. So I took you to the case of hide and hide when I said that marriage is a voluntary union for life between one man and one woman, monogamous marriage, not polygamy under the Act. And the principles we are concerned with for the purpose of the bar exam stems from statutory marriage. I repeat, what you should read, understand, and apply are principles in statutory marriage. You are not concerned with customary marriage. You are not concerned with Islamic marriage. You must take this into consideration. It is very important. And the statutory marriage here is a union for life between one man and one woman. A union for life between one man and one woman. Now, quickly, let's get to the requirements for a statutory marriage. Yes, these requirements are important because where they are missing, it could be a ground to challenge the marriage. So requirements of a statutory marriage. Number one, the parties must be of age. The parties must be of age. And the age of marriage is 18 years and above. The parties must be of age. Number two, consent of the parties is required. Number two, consent of the parties is required. Number three, parental consent is required. Number three, parental consent, where the parties are below the age of 21. Parental consent, where the parties are below the age of 21. Number four, the parties must not be married before. Yes. Previous marriage nullifies the subsequent marriage. It is that serious. The parties must not be married before. And this is important, although we'll come to this more in nullity of marriage, one of the relief sorts. Then number 5, the parties must be outside the prohibited degrees. The parties must be outside the prohibited degrees. Now, class, there are 2 prohibited degrees. There is the prohibited degree of affinity and the prohibited degree of consanguinity. I repeat, the prohibited degree of affinity and the prohibited degree of consanguinity. Now, for the prohibited degree of affinity, it means that the parties to be married are related, although not by blood. Yes, for affinity, they are not related by blood, but they are still related. Maybe first cousins, in-laws, and all that. So that is the prohibited degree of affinity. Now, for consanguinity, it applies where the parties are related by blood, where the parties are related by blood. For example, a brother and sister decide to get married. Now, they are within the prohibited degree of consanguinity. And this is one of the requirements for a valid statutory marriage. Please take note of that. Yes. Now, to commence an action for matrimonial causes, it is commenced by petition. I repeat, matrimonial causes is generally commenced by petition. It is commenced by petition. And the parties here are the petitioner and the respondent. The petitioner is the person instituting the action, and then the respondent is the person against whom the action is instituted. So, class, the parties to matrimonial causes are the petitioner and respondent. You must know this. The law makes provision for a co-respondent with respect to adultery. I repeat, the law makes provision for a co-respondent with respect to adultery. This means that where adultery is alleged, the adulterer or the adulteress, the person that joined in committing adultery, would also be joined as a party to the suit, will be joined as a co-respondent to bear liability and damages and all that. So please take note of that. The parties, petitioner and respondent. Now, where adultery is alleged, the adulterer or adulteress will be joined as a co-respondent. This is very important. Now, if there's an objection, the cavator, that's the person making the objection, would enter forbidding beside the names of the couple displayed on the notice board. I repeat, the cavator enters forbidding beside the name of the couple displayed on the notice board for marriage. And by writing this forbidding, he has made an objection. Now, this objection must be decided by the court, by summary hearing. Yes, when objection, the matter goes to the state high court. And after the decision of the court, the registrar may go ahead to issue registrar certificate. So take note of that. Once an objection is made by writing forbidding, the matter goes to the court, summary hearing, and the court is actually the state high court. Now, the court has 2 options. The court will either overrule the caveat or sustain the caveat. Yes. So if the caveat is overruled, that is, the caveat is removed and the registrar will go ahead to issue registrar certificate. But if the caveat is sustained, it withdraws the issuance of registrar's certificate. Take note of this, class. It is very important for the conduct of marriage under registrar's certificate. Now, I said within 3 months, the registrar issues registrar's certificate. Issues registrar's certificate. And upon issuing registrar's certificate, it gives an avenue to the parties, to the couple, to celebrate marriage in the 2 places I've mentioned. Now, with the registrar's certificate, that is Form C, marriage may be celebrated in a licensed place of worship or the marriage registry. Take note of that. So that is the first procedure for conducting marriage under registrar's certificate. Quickly, let's get to the second procedure. And the second procedure is marriage under license. I repeat, class, the second procedure is marriage under license. This is different from marriage under the registrar's certificate. Now, for marriage under license, the first we must understand is what a license actually is. A license is simply a document issued by the minister. A license is a document issued by the minister to intending couples, planning to marry. Now, upon issuance of this document, it is an authority to the couples to celebrate marriage. Yes, the license is a document issued by the minister. Now, upon issuing this document, it dispenses with the provision of the registrar's certificate. With a license, the couple can go ahead and celebrate marriage, either in a licensed place of worship or in the registry. So this is the procedure for license. The procedure for license is straightforward. An application is made to the minister. The minister issues a document known as the license. Now, that license is an authority to the couple to celebrate marriage without registrar's certificate. Listen carefully, it is important. So these are